For years, bringing a husband, wife, parent, or child to the United States has meant one thing: waiting. Waiting 12 months, waiting 18 months, sometimes waiting more than 2 years just for the first approval. During that time, families have missed birthdays, anniversaries, graduations, even the birth of their own children. Entire chapters of life unfolding across borders while a single petition sat in a queue. But starting in February 2026, something changes. Not a small tweak, not a quiet policy memo buried on a government website. A structural shift in how I-130 petitions are processed, a shift that, for many families, could cut processing times in half, in some cases even more. For certain immediate relatives, what once took well over a year could drop to just months. And for a subset of cases, there may finally be an option to receive a decision in as little as 15 business days. The key questions are: who benefits the most? What exactly is changing behind the scenes at USCIS? If you already filed, will you actually see any advantage? Because here's the part most people aren't talking about. Depending on your category, filing strategy, and timing, February 2026 could either dramatically speed up your case or barely move your overall timeline. So if you're separated from someone you love, or you're just starting the family-based immigration process, what you do over the next months could shape your entire journey. Let's break down what's happening and what it means for your family. Hi, I'm Sophia, and welcome back to Immigration Monitor, where we break down immigration changes in a way that's clear, realistic, and actually useful for your real-life situation. Today we're talking about one of the most meaningful operational shifts in family immigration we've seen in years. Major changes to the way I-130 petitions are handled starting in February 2026. If you're a U.S. citizen filing for a spouse, parent, or unmarried child under 21, or a green card holder sponsoring close family, these changes could directly affect your timeline. In this video, we'll cover what the I-130 backlog has looked like in recent years, what's changing inside USCIS, staffing, technology, and workflows, the expansion of premium processing to certain I-130s, how RFEs and humanitarian expedites are being handled under the new system, realistic new processing time projections and examples, and, most importantly, what you should actually do now based on your category and urgency. By the end, you'll know whether February 2026 is just good news for you, or a genuine turning point in your family's immigration journey. Let's start with why this matters so much. The I-130 petition, officially the petition for alien relative, is the foundation of almost all family-based immigration. It doesn't give a green card, work permit, or travel authorization. Its job is simple but crucial: to prove a qualifying family relationship between a U.S. citizen or lawful permanent resident and the relative they're sponsoring. Think of it as the first domino. Until that domino falls, nothing else can move. No national visa center processing, no consular interview, no adjustment of status, no immigrant visa. For years, that first step has taken far too long. Depending on the service center and category, families have routinely waited 12-24 months just for I-130 approval. And that was before National Visa Center document review, consulate interviews, scheduling medical exams and security checks, adjustment of status processing if the relative was already in the U.S. So, families were stuck at the starting line for a year or more, watching the calendar while very little seemed to happen. The impact hasn't just been numerical, it's been deeply human. Spouses spending anniversaries on video calls, parents watching their kids grow up through screenshots, adult children trying to care for aging parents from another continent, financial strain from running 2 households or constant travel, anxiety from not knowing whether it'll be 12 months or 24, a mix of pandemic disruptions, staffing shortages, increased filing volume, and old paper-heavy systems created a backlog that was slow to unwind even as offices reopened. Some service centers became badly overloaded while others moved a bit faster, creating huge frustration and a feeling of powerlessness. That's the context in which these February 2026 changes are happening. They're not cosmetic. They're a long-delayed response to a structural bottleneck that's affected millions of families. So, what is USCIS actually changing to make faster processing realistic? First, staffing, and not just by a small margin. USCIS has significantly expanded its adjudications workforce with hundreds of additional officers trained specifically to focus on family-based petitions. Instead of generalists juggling many case types, more officers will now concentrate primarily on I-130s. That matters because immigration processing is, at its core, a capacity problem. When the number of incoming cases is higher than what officers can complete, backlogs grow. When staffing finally exceeds intake for a sustained period, the agency can begin shrinking the queue. But it's not only about hiring more people, it's about how they're deployed. USCIS is consolidating certain family-based workloads into more specialized units. Officers reviewing the same type of petition repeatedly develop stronger pattern recognition. They know what complete documentation looks like. They see common issues quickly. They can make consistent decisions faster, with fewer unnecessary delays. On top of that, there's more dynamic case distribution between service centers. Instead of letting one center drown while another has extra capacity, USCIS can shift workloads based on real-time data, making it less likely that your case gets stuck simply because of where it landed. Internal performance benchmarks have also been updated. Units are now working with clearer time targets for resolving I-130s while still maintaining legal review standards. However, even with more officers, an outdated paper-based system can still drag everything down. That's where the second major change comes in: technology and digital workflow. For years, one of the biggest hidden slowdowns has been the way files move around. Paper filings had to be scanned, uploaded, physically moved between locations, re-scanned when RFEs were issued and answered. Every handoff created friction and delay. Under the new framework, more I-130s are being fully integrated into an end-to-end digital workflow from day one. Officers see case documents on a unified dashboard instead of chasing scans and physical files in different systems. USCIS has also deployed improved document recognition tools to help officers quickly identify key civil documents, marriage certificates, birth records, prior immigration filings, without replacing human judgment. This reduces the time spent on repetitive administrative tasks so officers can focus on the substance of the case. Internally, supervisors can now see real-time data on how long cases have been pending in their units, which makes it easier to spot bottlenecks early and shift resources before delays escalate. For petitioners, online USCIS accounts are gradually becoming more useful. In more cases, you'll be able to upload certain follow-up documents, especially responses to requests for evidence, directly through your account rather than printing and mailing large packets. That alone can save weeks of mailing and intake time. All of this ties into one of the most frustrating parts of the old system: RFEs, or requests for evidence. Historically, an RFE could easily add 3 to 6 months to an I-130 timeline. You'd wait months for initial review, get an RFE, spend weeks gathering what USCIS wanted, mail it in, then wait again for it to be scanned, queued, and finally reviewed. Starting February 2026, USCIS is making RFEs more targeted and less disruptive. Filing instructions are clearer and more tailored to each relationship type. Spousal cases get more explicit guidance on bona fide marriage evidence. Parent-child cases get clearer instructions on birth documents and prior marriages. Officers are being trained to issue RFEs that are narrower and more specific, pointing to exactly what's missing, like a divorce decree, a translation certification, or a specific civil record. And, where available, petitioners will be able to upload RFE responses online, avoiding mailing delays and scanning backlogs. The goal is fewer RFEs overall, and when they do happen, a faster, more predictable cycle. But the change that's attracting the most attention, and for many families will be the single biggest game changer, is the expansion of premium processing to certain I-130 petitions. For years, people watched employment-based applicants use premium processing to get 15 business day decisions, while spouses and parents of U.S. citizens had no such option. That begins to change in February 2026. USCIS is expanding premium processing eligibility to include certain immediate relative I-130s filed by U.S. citizens, specifically U.S. citizens filing for a spouse, U.S. citizens filing for an unmarried child, under 21 U.S. citizens age 21 or older filing for a parent. For these categories, petitioners will be able to request premium processing for the I-130. The planned fee is $2,500, and in return, USCIS guarantees a decision within 15 business days. That guarantee is important to understand. It guarantees a decision, approval, denial, or an RFE, not an automatic approval. If the case is weak, incomplete, or inconsistent, premium processing will not save it from a denial or further scrutiny. But for well-prepared cases, the impact is huge. Instead of waiting 12-18 months for an I-130 approval, many families could have that first crucial step completed in about 3 weeks. This is especially powerful for immediate relatives because they are not subject to annual visa caps. Once the I-130 is approved and the National Visa Center work is done, they can generally move straight to an interview and immigrant visa issuance, or in the US, to adjustment of status. That said, premium processing does not speed up National Visa Center, document review by itself, guarantee faster consular scheduling abroad, waive required background checks or medical exams, override visa number limits for preference categories. It accelerates the petition stage. For most immediate relatives, that stage has historically been the single longest part of the journey. For them, cutting a year off the front end can translate almost directly into reuniting a year earlier. However, the $12,500 fee is substantial. Whether it's worth it depends on how urgent your situation is, how long standard processing is taking when you apply, whether your category is even subject to visa backlogs. If your category faces long visa bulletin waits, like adult children or siblings of U.S. citizens, premium processing on the I-130 alone will not erase a 6 to 10 year backlog. It just gets your petition approved and your priority date locked in faster. We'll talk strategy in a moment, but there's one more key shift that affects both regular and premium cases: how urgent humanitarian situations are evaluated for expedited processing. Expedite requests have always existed, but outcomes have often felt unpredictable. Criteria were broad and applied inconsistently. Some serious cases were approved, others weren't, and it was hard to understand why. Beginning February 2026, USCIS is standardizing and clarifying how it evaluates expedite requests for family-based petitions. Priority consideration is more clearly defined for cases involving serious medical conditions affecting the petitioner or beneficiary, U.S. military families facing deployment or relocation, minor children separated from parents where documented hardship exists, credible threats to personal safety or severe instability in the beneficiary's country, other documented compelling humanitarian concerns. The key difference isn't that expedites will suddenly become easy. They won't. It's that the process will be more transparent and evidence-driven. To have a realistic chance, families will need strong supporting documentation, such as detailed medical letters from licensed physicians, military orders or deployment documentation, police reports, or credible evidence of safety threats. Country condition reports tied specifically to the beneficiary's situation. Vague hardship statements will rarely be enough, but well-documented cases should see more consistent, predictable evaluations than in the past. Importantly, premium processing and expedited handling are not mutually exclusive. A family might use premium processing to get a fast I-130 decision, then request expedited handling at later stages, like NVC processing or interview scheduling, if their circumstances justify it. So, what do realistic timelines actually look like under this new system? Under the old structure, immediate relative I-130s, spouses, unmarried children under 21, and parents of U.S. citizens often took 12 to 24 months to approve. Then, NVC processing might add 6 to 12 months. Consular interview scheduling could add several more months. Depending on the country, total time from I-130 filing to visa issuance could easily land between 24 and 36 months, sometimes longer. Under the new framework, starting February 2026, USCIS is targeting standard processing times for immediate relatives in the range of about 6 to 9 months for most cases. For families who choose premium processing, the I-130 approval could come in 15 business days. NVC and consular stages will still vary by country and workload, but if you remove 12-18 months from the petition stage alone, total separation time drops dramatically. Here's a simplified example. Imagine Ana, a US citizen in California, petitioning for her husband in Brazil. Under the old system, I-130 approval, hard 16 months, NVC plus interview scheduling, Yamos 10 months, total around 26 months. Under the new system with standard processing, I-130 approval, Jikers 7 months, NVC plus interview, Jutras 10 months, total around 17 months. Under the new system with premium processing, I-130 approval, Dutch 3 weeks, NVC plus interview, that's 10 months, total roughly 11-12 months. That's cutting separation almost in half compared to many recent experiences. Now consider family preference categories, which are subject to annual visa limits. F1, unmarried adult children of U.S. citizens. F2A, spouses and unmarried minor children of permanent residents. F2B, unmarried adult children of permanent residents. F3, married children of U.S. citizens. F4, siblings of U.S. citizens. For these categories, your place in line is set by your priority date, the day USCIS receives your I-130. Faster I-130 processing helps you get that date established and approved sooner, but it does not remove multi-year waits caused by visa number limits. Under the old system, I-130s for these categories might take 18-24 months or more. Under the new framework, USCIS is aiming for most to be processed in around 6 to 9 months. If your category has, say, a 7-year visa bulletin backlog, cutting I-130 processing from 20 months to 7 months effectively moves you 13 months closer to the finish line. That's meaningful, but it doesn't turn a 7-year process into a 1-year one. This is especially important for applicants from countries with long backlogs like Mexico or the Philippines in certain categories, where the visa bulletin moves slowly and sometimes retrogresses. So, with all of that in mind, what should you actually do now? It depends heavily on who you're sponsoring and how urgent your situation is. If you are a U.S. citizen petitioning for an immediate relative, spouse, parent, or unmarried child under 21. If you have not yet filed, if your situation is urgent and you can afford it, there's a strong argument for waiting until premium processing becomes available in February 2026, then filing with a well-prepared, complete petition. That could turn a potential 12-18 month wait into about 3 weeks for the I-130 decision. If you can't wait due to current hardship, unstable conditions, or visa issues, it may make sense to file now and then, if allowed, upgrade to premium processing once expansion takes effect. If you already have a pending I-130, you may still benefit from the overall staffing and workflow improvements as USCIS pushes older cases forward. If USCIS allows upgrades for pending petitions in your category, you can decide whether the remaining expected wait justifies paying the premium fee. If your case is already close to normal processing times, upgrading might not be necessary. If you are in a preference category subject to visa bulletin backlogs, in these categories, your priority date is everything. Delaying your filing by several months so you can file under the new system might not be wise because you're giving up months in line. In most cases, it's better to file as soon as you're ready with a strong, complete petition, even if current processing is a bit slower, so that your place in the visa queue is locked in earlier. For these cases, premium processing, if it ever expands to more categories, would speed up the I-130 decision and priority date confirmation, but would not remove multi-year visa bulletin waits. No matter your category, preparation is more important than ever in a faster system. Well-prepared petitions get the most benefit from quicker processing. Thin, incomplete, or disorganized filings may simply reach a denial or RFE sooner. Before you file, make sure you've included clear proof of the petitioner's U.S. citizenship or permanent residence, certified copies of birth or marriage certificates, divorce decrees, or death certificates for all prior marriages, if applicable. For spousal cases, strong evidence of a bona fide marriage, such as joint leases, bank accounts, insurance policies, tax returns, photos over time, messages, travel records, and evidence of shared responsibilities. If you're thinking about premium processing, begin budgeting now. Ask yourself, how much time could this realistically save in your situation? How much is that time worth to you given the fee? Is your documentation strong enough that a 15-day decision is more likely to be an approval than an RFE? Also, prepare for the next stage before your I-130 is even approved. For consular processing, start collecting civil documents early: birth certificates, police certificates, updated passports, and any country-specific records that take time. For adjustment of status in the US, learn what's required for the I-485, medical exam, and financial sponsorship, and start gathering that evidence now. That way, when your I-130 is approved, whether through standard or premium processing, you don't lose months scrambling for the next set of documents. Finally, keep an eye on official USCIS announcements. Fees can increase, implementation details can shift. Specific rules about upgrading pending cases to premium processing will matter. To clear up a few common questions, will pending I-130s benefit from these changes? Yes, in the sense that more officers and better workflows are meant to reduce the overall backlog, not just new filings. But how much faster your specific case will move depends on where it is in the queue and which service center holds it. Can you upgrade a pending I-130 to premium processing? For eligible immediate relatives, USCIS is expected to allow upgrades once premium expansion goes live, through a separate premium processing request and fee. We're still waiting for final detailed guidance on exactly how that will work. Does faster I-130 processing guarantee a faster green card? For immediate relatives of U.S. citizens, generally yes, because there are no annual visa limits. For preference categories, no, the visa bulletin and visa number limits still control the overall weight. Does this change much for siblings or married adult children of U.S. citizens? It does help get petitions approved faster and lock in priority dates sooner, but it does not erase the long visa bulletin backlogs those categories face. Stepping back, these February 2026 changes don't rewrite U.S. immigration law, they don't change visa quotas or the structure of the family-based system, but they do send a clear signal. When families follow the legal path, the process should function more efficiently and predictably. That predictability matters. When average I-130 timelines stabilize around 6-9 months instead of swinging wildly between 12 and 24, families can actually plan when to leave a job, when to move or change housing, when children might need to switch schools, how long they may need to maintain two households. Premium processing gives some families with urgent needs a way to purchase speed at the petition stage. Clearer RFEs and more structured expedite criteria reduce guesswork and inconsistent outcomes. Better digital tools help prevent files from vanishing into black holes for months at a time. At the same time, it's important to stay grounded. Country-specific visa limits, consular staffing, background checks, and medical requirements all remain. Global events can still cause delays at embassies and consulates. This is real progress, but it is not a magic shortcut around the law. For immediate relatives of U.S. citizens especially, though, this may feel like a turning point. If you've put off filing because you were dreading a 2-year wait just for an I-130, the February 2026 system changes that equation. If you've been counting months of separation with no clarity in sight, the possibility of a 15-business-day decision can change how you think about the future. So as you plan your next steps, approach this moment strategically. Know which category you're in. Understand whether visa caps affect you. Decide whether premium processing is worth the cost in your situation. Prepare your documentation thoroughly so you can actually benefit from a faster system, and stay informed as USCIS releases more details on implementation. If this breakdown helped you understand what the February 2026 I-130 changes could mean for your family, make sure you stay connected with us here at Immigration Monitor. As new guidance, forms, or filing procedures roll out, we'll keep breaking them down in clear, practical terms so you're never left guessing. Share this with anyone you know who's separated from a spouse, parent, or child, or who's about to start the family-based immigration process. For many of you, February 2026 won't just mark a policy change, it may mark the beginning of the end of a long separation.